Everyone. I'm going to cover, I'm going to address practice tips for IPR success. But before I get there, why IPR? They're growing in popularity, and there must be a reason for it. Well, the reason for it is that it's really the preferred forum for challenging patent validity. And the reason that is that there's a relatively low bar for obtaining granted petition. You just have to show a reasonable likelihood that you'll succeed on at least one of the challenge claims. The patent is not presumed valid. The preponderance of the evidence burden of proof instead of the clear and convincing evidence burden of proof to invalidate claims in the district court. So lower burden of proof. Perhaps the most attractive thing about the PTAB and IPRs is you have technically and legally skilled patent law judges. These folks know the technology, and if you have a strong invalidity case, you're in good hands. They'll understand it. Another benefit is that it's the broadest reasonable construction standard, which means the broader the claim is, the easier it is to invalidate. So that's a benefit to the person challenging a patent. And practically speaking, secondary considerations of alleged non-obviousness gain very little traction in an IPR, and the reason why is the PTAB judges are very strict on the patent owner to show a nexus between the challenge claims and the alleged secondary considerations. So your surprising results or commercial success, they're going to insist that those are commensurate with the scope of the claims being challenged. And typically, the claims are much broader, and you cannot establish that nexus. Now, having said that, I'll skip some of these bullet points and go on to the next slide. The rest of my slides are taken from a presentation by the PTAB itself from the Virginia State Bar CLE a couple weeks ago. So if anybody wants the full presentation from the PTAB, fire me an email and I'll send it your way. I've picked some selected slides that I thought were very good. So this is the PTAB talking, not Ralph talking. And the PTAB is probably more informative than I am. First, some statistics. The takeaway from this slide, slide number 5, is your odds are basically, well, the number of applications for IPR have increased dramatically. And in fiscal year 2015, we're probably going to see the double the number of IPRs filed as compared to 2014. The data for 2015 is basically just halfway through the year. And in a half a year, we've surpassed last year's total number. So they're gaining popularity, and they will continue to do so. Here's some more statistics. On the left-hand side, what this data shows you is basically your odds are 2 to 1 that your petition will be granted. Okay? Good odds. The slide on the right, IPR settlements, what that tells you is gives you incredible settlement leverage if you're the target of a patent infringement suit. Many of these IPR cases are settled before the petition's even decided. So it gives you great leverage. That's one of the reasons why defendants are filing IPRs. Here's another slide from the PTAB. The one that really matters is the row at the bottom. These are where the trials went to decision, that went all the way through. And what this data tells us that if you go to the map in an IPR and see it all the way to final decision, there's an 85% chance that at least some of the challenge claims will be held unpatentable. And a 65% chance that all of the challenge claims will be held unpatentable. So this is why IPRs are gaining popularity. It's a much more favorable forum to challenge validity than a district court. The statistics from a district court are not nearly this good for challenging validity. So here's kind of the timeline, the big events that occur in an IPR. And this is actually off the Patent Office site. You've probably seen this before. And I want to discuss a few of the major events in an IPR and a few kind of practice tips that you need to keep in mind. But before I get there, the one thing you should do if you're involved in an IPR, know the rules, study the rules, make sure you don't fall into any procedural traps. There's a lot of rules involved. I can't cover them all now, but if there's one piece of advice you take away from this is study the rules and know the rules and go in with eyes wide open. So the first thing you do is you file the petition. And for the petitioner, this is your first chance to make an impression. And your petition should include all your arguments and all your evidence. Don't hold your cards close to the vest. Show them all now because you may never get another chance. chances are the patent owner will file a preliminary response. So you need to set out your case early. The one piece of advice is include all your arguments in the body of the petition. Don't bury them in some declaration somewhere. And less is better than more. Provide a detailed analysis, your strongest position on your best prior art. Go with your best one or two arguments and have the courage to let go of the less persuasive arguments, the less persuasive prior art, because all they're going to do is clutter up your petition. You only get 60 pages. So take your best shot and have the confidence to go with your best shot and leave the other stuff behind. Claim charts. Got to have them. I mean, you're not required to have them, but you should have them. And the thing about claim charts is a lot of people trip up on and make mistakes is they include argument in the claim chart. The claim charts can be single-spaced, and in those claim charts, what I recommend is you just quote, exactly quote what's in the prior art reference that you're relying on that corresponds to the claim element. And then explain in the argument part of the petition why that disclosure meets the claim element. All right, don't make the mistake of including argument in the claim charts because your petition will be bounced. The Patent Office is very strict about that. And I've cited some frequently asked questions you can find on the website for details about the formatting of the claim charts. Claim construction. If you're the petitioner, you need to deal with it up front in the petition. There's inevitably going to be some key claim construction terms that you're going to need a favorable construction on for your validity case. And you need to address that up front in the petition, because if you don't, I can guarantee you that the patent owner will in their patent owner response. You may never get a chance to say anything about claim construction because after the patent owner response, the Patent Office may deny your petition. So don't pass up the opportunity to state your case for claim construction in the petition and point to the intrinsic record that supports your position, where in the spec supports your position and why, where in the file history supports your position and why. If you want expert declarations, then submit them to support your position, but do it up front. Next slide, lessons learned on experts. I think it's the rare petition that will not be accompanied by at least one technical expert declaration. I think it's a good practice to have a technical expert on board, but you need to use the expert correctly, and you need to keep the federal rules of evidence in mind. You would never put an expert up at trial who would say, well, you know, it'd be obvious to combine reference A with B, and it meets all the claim elements. Take my word for it. That's not how it works at trial, and that's not how it works in an IPR, an inter-party review. You need to provide the underlying factual basis and data that supports the expert's opinion. Otherwise, the board is going to give that expert opinion no weight at all. So be very careful to provide all the detail in the expert report or the expert declaration that supports the opinions. I see a lot of people make mistakes by not putting enough meat on the bone, so to speak. Obviousness. Lessons learned when arguing obviousness, which is typically the main argument in an IPR, is combining references. It's the Graham factors that apply. Two things you need to keep in mind. Number one, you need to point where in the prior art reference the element is allegedly disclosed. Stick the board's nose in it. Don't make them guess or go searching for it. Show them exactly where it is, number one. And number two, provide a detailed rationale or basis why one skilled in the art would combine the art. Again, have your expert explain. One skilled in the art would combine this art because it would reduce costs or it would lead to greater efficiency, and explain what efficiencies would be achieved or what cost benefits would be achieved. Avoid conclusory opinions. You need to set it out in detail. Why would these references be combined? Because if you don't, the board may just bounce your petition and say, you know, you haven't persuaded me that one skilled in the art would combine it. It's a conclusory opinion. I'm giving it no weight. All right, slide. Whoops. Another thing about experts and prior art that I want to caution people about, and it's not directly on this slide, is oftentimes we rely on unconventional prior art. Now, what do I mean by that? What I mean are like posters that are presented at a conference, or a paper that was presented at a conference, or standard setting documents that, the cellular standards that were in draft form. These are not self-authenticating documents. So you're going to have to, with your petition, submit expert declaration or a fact declaration that basically says, hey, I have personal knowledge. I presented this paper on July 12, 2013 at the conference in Boston. It was open to the public. I handed out copies of this presentation. You're going to have to prove up the prior art status of this unconventional art, because if you don't, I can guarantee you the patent owner in the preliminary response will point to that and say, you haven't proved that's prior art. You haven't authenticated, you haven't proved its prior art status, your petition should be denied. And you know what? The board will deny it. So be very careful with unconventional prior art. All right, so those are kind of a few practice points for filing a petition. Now the next step is the patent owner preliminary response. And this is the patent owner's chance to take a kill shot. All right, this is where you can stop the petition dead in its tracks, because once that petition's granted, the odds are against you. So take a look at the petition. Are there some fatal defects that you can take advantage of? And here are just a few examples of some of the fatal defects you can look for. As the petitioner filed the petition outside the one-year statutory bar, in other words, were they served with a complaint asserting these patents? If they don't file the petition for IPR within that one-year period after being served with a complaint, too late. You can knock out the petition. Was there a failure to identify the real party in interest? If so, you can knock out the petition. What are the weaknesses? Are there fatal weaknesses in the petitioner's case? Is there a claim construction that is just totally out of whack, makes no sense, vulnerable to attack, that you can convince the patent office is wrong and deny the petition based on that? Are the cited references, in fact, not prior art? It's the unconventional prior art I'm talking about. Has the petitioner failed to establish that this prior art is authentic, that it is indeed prior art? If there's a failure of proof in the petition, that's a kill shot you can take. Does the cited reference lack a material claim element? These are easy kill shots, so take advantage of it if you have one. All right, next slide. All right, so you get a decision on the petition, and now what? Well, one of the things that you should keep an eye out for is there's an opportunity for joinder. Say for whatever strategic reason you decided not to file an IPR against a patent you've been sued on, but lo and behold, the IPR is granted. Well, you can still get in the game and have your say. And how do you do that? Well, you file a petition and a motion to join the IPR within 1 month of that IPR having been granted. And the key to success in getting joinder is don't add any new arguments, any new prior art, any new issues. Kind of play the hand that the original petitioner is playing. And if you do that, and if you establish you won't affect the schedule in the original petition, you're going to have a good shot of joining that petition and having your say with respect to the hand that the original petitioner is playing. And I've cited some cases here, one way granted joinder, one case, and one case denied it. You can take a look at those. But the key is don't add too much, if anything at all, to the issues that are already in play, and you'll get joinder. All right, discovery period. Now, the patent owner will have a chance to respond, and then there's a discovery period amongst all this back and forth where you can take depositions. But the bottom line is you're not going to get much discovery, all right? This is not district court litigation, no scorched earth mentality. You're going to get very focused, limited discovery, but you know what? You're going to get what you really need. And so that's what's important. Now, there's 3 types of discovery. You can agree with the other side in initial disclosures, and we'll agree to exchange certain information. I don't see that happen too much. The typical discovery is what's called routine discovery. So what is that? You're going to get the cited exhibits. You're going to cross-examine the declarants that each side relies on. And each party is obligated to produce information that's inconsistent with the position they're taking in their papers. For example, I'm a patent owner and I'm arguing that my claims, the combined A and B, and you get surprising results. But I know I have a lab notebook where we combined A and B and the results weren't all that surprising. Under the rules, I have to voluntarily hand that over because it's inconsistent with the position I'm taking in the IPR. All right? Additional discovery. Well, don't plan on getting it. You're not going to get it. unless it's a very rare situation, and you probably don't need it anyway, so don't fret. I've cited a case here, Garmin versus Kuzo. I'll send you these slides, but these are the things you need to show to get additional discovery. But like I said, don't plan on getting it, and play the cards you will get, and that is the routine discovery. And like I said, it's all you're going to really need anyway. All right, depositions. I want to make a few points about depositions. 2 points about depositions. This is not your typical district court fact deposition. You're cross-examining expert witnesses, and you should treat that cross-examination as if the judge and jury were sitting there, or if the patent law judges were sitting there, because you're creating trial testimony. And the last thing you want to do is to ask careless or questions that gives the expert an opportunity to supplement their opinions with even more bad stuff that kills you. All right, you don't want to do that. You want to very tightly control that witness, that expert. You want to ask questions that either you know the answer to, you don't care what the answer is, or number 3, you have them locked in with impeachment. So if they say the earth is flat, you've got a paper in your folder put in front of them that in a prior life they said, well, the earth is round. You can impeach them. So be very careful. As far as defending depositions, again, it's not the typical district court deposition. You need to state your objections, no speaking objections, but you need to state your objections so the board can rule on them later. So if there's a question, your objection should be objection, lack of foundation, objection, hearsay, objection, irrelevant. If you don't make your objection, you waive it. It's gone. So you have to speak up. Be careful with new exhibits that they put in front of the witness. If you don't object to that exhibit at the deposition, it's in the case, and you waive your objection. So be careful. Okay, so last thing, and I'll hand this over, is oral hearing. Bottom line is oral hearing is like an appellate argument. You need to know your record inside and out, all right? You're going to have a panel of 3 judges, maybe more. Some may participate by video. At least one is going to be very prepared. I've had our oral argument where all 3 were very prepared. I got 1 word out of my mouth and was peppered with questions for the next 20 minutes. So what do you need to do to prepare for that? Number 1, you know your weakness in your case. Know it, because they're going to go after it. So be prepared to answer the question. Answer the judge's questions directly. Don't evade them. Answer them directly, and if you need to follow up with an explanation why your answer didn't just kill you or why your answer doesn't matter, then explain after you directly answer the question. They're going to sniff out if you're evasive and you're going to lose credibility. These are smart, talented judges. So be prepared. Know your slide deck. I recommend you have demonstratives, but know it well enough. So if the judge asks you a question, you go to slide 32. You know exactly where your answer is, what you need to show him, and you pull up the slide and say slide 32. So the court reporter knows what slides you're pulling up. No new evidence in the demonstratives. You got to stick with the record as it exists. So I think I'm getting at the end of my time. I haven't read my slides to you. I've gone a little bit off of them. But one thing I want to say about settlement, you can settle these things at any time. You have to file a copy of the settlement agreement, even if it's confidential. You can file it under seal. But keep in mind, if you settle too late in the process, the board may not terminate the proceedings. If you settle 3 weeks before oral argument, the board may say, well, we put a lot of work into this. We're going to decide this case. It's great that you settled. So with that, I'm going to pass this on to Mr. Beaupre, John Beaupre. I put up the Brinks code here. I skipped a few slides. Slide 30, it's CLE code number 1, Brinks. And with that, I'm going to pass it to my partner, John Beaupre.
Thank you very much, Ralph. And so today I'm going to be talking about the recent proposed rules changes in AIA proceedings. Just to orient everybody, the AIA proceedings were enacted in September of 2012, and then about 2.5 years later, in March of 2015, so earlier this year, the PTO announced a couple of quick fixes, and those were immediately effective. They were relatively minor changes, and then about a month ago, in August, the PTO announced a second round of proposed rule changes, and that's what I'm going to focus on mostly today. These are proposed changes, so they have not yet taken effect. There's a public comments period that closes in about 3 weeks, and then by the end of the year, the Patent Office expects to finalize and implement this second round of changes, and then there's a potential third round coming up, but that's on the horizon. So like I said about those quick fixes from earlier in the year, they were relatively minor. One was increasing the page limit on briefing and for motions to amend, and then claims could also be listed in the appendix. And as a note here, there are some websites, commonly used websites like Cornell's Legal Institute that don't show this rule amendment, and so make sure you're using the most recent rules. And maybe Cornell has updated it recently, but in the last couple days they haven't. And then the rule changes that we're going to talk about mostly today, they are, the first one is the patent owner's preliminary response. And I'll go through these in a little more detail. I'll just summarize them now. There's a Rule 11 certification. There's a clarification on the claim construction standard. Motions to amend. There haven't been any changes, but there's it's a good summary of recent decisions. Although our partner Alan Elliott is going to talk about those next, so I'm going to stay away from that. And then oral hearing and page limits have a couple of minor tweaks that are noteworthy, especially with page limits. Now, with what's probably, in my view, one of the most significant changes, the patent owner's preliminary response. So a preliminary response, to orient everybody, that's filed 3 months after or within 3 months after the petitioner's original petition. So there's the original petition, then the patent owner has the right to file a preliminary response. It's not, the patent owner is not required to do so, but most patent owners choose to do so. And, but they're restricted in what they can say. Under current rules, the patent owner is not allowed to submit new testimony, just old prior testimony, such as transcripts or affidavits from another case that were either by the petitioner's declarant or an expert that the patent owner would like to use, things of that nature. So it's relatively limited. And so the proposed rule would allow the patent owner to file this new type of evidence. Well, because of the timeline here, like I mentioned, it goes petitioner's petition and patent owner's preliminary response, and then the next thing that the parties see is the institution decision from the PTAB. And so the PTAB needs to understand or have some guidelines on what to do if there's factual disputes between those two declarations under these new proposed rules. And what the PTAB is proposing to do is to temporarily resolve disputed facts in favor of the petitioner. This is actually, this may sound like a familiar standard. It's pretty close to Rule 12 of the motion to dismiss, where you presume disputed facts in favor of the party that's opposing the motion. And then, so what would be the effect of this rule change? I think there's a couple things that we may see. Patent owners may file even more preliminary responses. Like I said, they're optional. They're currently filed in about 80% of cases. And actually, even before these rules took effect, or before the proposed rules were announced, this was trending up. For 2015, it's 85% of patent owners who file a preliminary response. We also may see the preliminary responses may be longer and include more arguments. This is especially true, as Ralph mentioned earlier, that these AIA proceedings, you cannot add new matter at the end. You have to have all of your arguments in the papers, and the PTAB is very strict about this. So petitioners and patent owners are always looking for ways to add more meat on that bone, to borrow another one of Ralph's phrases. And another thing that we may see, though, is that some patent owners may be leery about presenting something to the PTAB and having the PTAB's first impression of an argument to be viewed through through lenses that are favoring the petitioner. That may be overthinking it a bit. I think, in general, the more you get to put an argument in front of the PTAB, the better you will be. They're smart judges. They know what they're doing technically and legally. But some people may look at this and say they want to save an argument or two. not unlike waiting for summary judgment instead of a motion to dismiss. Okay, the next major rule change is actually it's been one of the headliners, if not the headliner for this set of proposed rule changes, but really it's much ado about nothing. It's a Rule 11 type certification that basically adds almost all the provisions from Federal Rule 11 it codifies it into the PTAB regulations. The one difference is there's no proposed monetary sanction as you see directly in Rule 11. However, that can be backdoored. Monetary sanctions are available and have been available through 37 CFR 42.12. And in fact, another reason that I mentioned this change is not a big change is the fact that the sanctions that are defined and available to the parties remain unchanged. 37 CFR 42.12 still includes everything, or still would include everything that it currently includes, such as excluding evidence, expunging papers, precluding discovery, etc. And then this slide we can gloss over pretty quickly because, like I said, I don't think this Rule 11 change will have a big effect on practice. People have been on their best behavior in front of the PTAB already. They have the PTAB judges that they don't want to deal with side issues, and they're very quick to shut down any misconduct by the parties or games playing. Next is the third major change or proposed change that I'll talk about, the claim construction standard. There's no proposed change to the standard itself. It would remain broadest reasonable interpretation in view of the specification. But there is a slight clarification, and that is the current rules state that the BRI standard, broadest reasonable interpretation, does not apply to expired patents. It says it applies to any, quote, unexpired patent, but it doesn't specify the time frame during which it determines if a patent is not expired or not. Well, that was actually a pretty logical thing. I think most people figured out, but the PTAB is proposing clarifying it and saying that carve-out applies to patents that will expire during the proceedings. And so that should be straightforward, especially given the fact that the timing of these proceedings is very predictable. The PTAB has 12 months from the date of institution to issue its final decision. There is a provision that allows a slight extension, but the PTAB has never had to extend the proceedings. So assuming that you have 6 months from the date you file your petition until the date that the PTAB issues its decision on institution, you will know when the proceedings are going to end. It's going to be 18 months from filing of the petition or 12 months from the date of institution. Now finally, this was filed away under kind of miscellaneous proposed changes. This is page limits, and actually these have a big effect, I think. So currently, and let me explain why real quick. As I said earlier, every word counts in these petitions, because if you don't introduce and fully explain an argument to the PTAB in your papers, you're not going to have a chance to introduce it at oral argument. They're very strict about new material. And so with IPR petitions and preliminary responses, and then the patent owner's full response, those would be 14,000 words instead of 60 pages. Now the PTAB doesn't have a calculation. If you look at the bottom, this 250 words per page number that I included, that doesn't come from the PTAB. That came from an older Federal Circuit bar report where they were looking at the average number of words per page for similar fonts and margins, 14-point fonts and 1-inch margins, and they said it was about 250 words per page. So using that rough metric, 14,000 words is about 56 pages. And so essentially for the petition itself, you would be losing 4 pages. For a PGR and a CBM response, or a petition and response, it would be 75 pages instead of 8. And then down near the bottom, when we talk about the replies to patent owner responses, now this is a page limit where it's a bit all over the place. It started out as 15 pages, and then in March the PTAB changed it to 25. And this is the provision that I said is not updated on all of the commercial sites necessarily. So look for that. Look at the actual regs. And so it was instituted as 25 pages in March, and then if this proposed rule is instituted by the end of the year, the page limit will be, instead of page limit, it'll be 5,600 words, which is a little over 22 pages. So when Ralph earlier talked about following the rules and making it procedurally accurate, this is a big one. You don't want to miss pages that you're allotted, and you don't want to go over because the PTAB won't consider those pages. So make sure you're following these rules and know when they're instituted. And then finally, another way that I think these word limits would affect the way practitioners and parties prepare their papers. So currently, there's not a lot of room for charts. If you want to use a chart, especially something taken right out of a prior art reference, and you want to annotate it to make it more clear, or to make sure you specify what you're asserting it corresponds to a different element, then you're basically giving up a lot of space to do that. But under this new 14,000 words limit, I think you can use charts a lot more. And by charts, I don't mean a flow chart with a lot of words necessarily, because those may count. I mean diagrams, figures from patents. So I think we're going to see that a lot more. And I think also we'll probably see more consistent and easy to read claim charts, because right now, when it's under a page limit, you really sometimes have to finesse your claim charts. And they look a little weird at the end to make sure that you're minimizing dead space. So those are some predictions on how I think it's going to play out. And now I'm going to hand it off to Alan Elliott. But before she explains to us about motions to amend, the CLE code number 2 is post-grant patent, and there's a dash in there. So I guess please make sure to include the dash. And Alan, thank you.
Hello. As John mentioned, I am going to discuss motions to amend. So we started out at a high level with Ralph's presentation, got a little bit further down in the weeds with John, and then here with my presentation, I will be much more specific on one particular area, which is motions to amend. Let me move forward here. And here I have the first slide, which is a timeline, and it'll provide a general background or backdrop to what I'll be discussing here today. And the first date is September 16th, 2012, which is when the IPRs first went into effect. And with that, the statutory basis for motions to amend is at 35 U.S.C. 316D. And along with that, we have the Patent Office rules that are at 37 CFR 42.121. And with these rules, the laws and the rules, they provide for the patent owner being able to file one motion to amend unless they're given permission by the board to file another motion to amend. And I'll discuss in idle-free systems where the patent owner was allowed to file a renewed motion to amend. And the patent owner can cancel claims or can propose a reasonable number of substitute claims. The presumption is that there will be one substitute claim per challenged claim. You cannot enlarge the claim scope or introduce new matter. Your motion to amend can be filed no later than the patent owner response, and you must confer with the board prior to filing the motion to amend. And then the last point on here is the Master Image 3D Inc. v. Real D Inc. There was an order on the conduct of proceedings here, and that was from the previous summer in July. And I'll discuss idle-free systems, and then John discussed briefly the quick fixes in March, and then these came down as final rule amendments in May. And essentially the only thing for motions to amend that came out of those quick fixes and then final rules was that the motion to amend the page limit was increased from 15 to 25 pages, and patent owners are now able to include their claims as an appendix rather than in the body of the motion itself. So now moving, and here I have an excerpt from the code, and I went through that quickly. I'm going to be moving on to the graphic here, and you'll find that throughout my presentation. I'll primarily focus on the graphics, and then behind that, the slide deck will include a little bit more explanation so that you will have that as reference material if you want to have the slides later. So here, this is from Idle-Free Systems, which was one of the first IPRs that was filed and granted, and instituted. And what the board did here was take the opportunity in an order on a motion to amend to provide guidance on requirements for motions to amend. Bergstrom Inc. had filed a motion to amend, and the panel for this particular case was not happy about the way that Bergstrom had constructed its motion. And so they, as I said, they took this opportunity to provide guidance to patent owners. And I put them here into sort of 5 blocks. One of claim substitution, and that the patent owner must be, or the claim amendments must be responsive to a ground of unpatentability. The patent owner can't broaden the claim scope. The patent owner must show written description support and show patentability of proposed claims. And in this next slide, there's some details here for the first 4. The challenged claim can only be replaced by one claim unless special circumstances or a demonstration of special need has been shown. The motion to amend should identify for each proposed claim the challenged claim intended to be replaced, and all proposed claims should be traceable to an original challenged claim. The substitute claim must be responsive to an alleged ground of unpatentability. No broadening of claim scope, that's fairly obvious what that means there. And the patent owner must demonstrate written description support in the original disclosure, not in the patent as issued. This can also include having to show support in a priority application, such as a provisional, if you're trying to get priority all the way back to that provisional. Now, this next slide talks a little bit more about the patent owner's duty to show patentable distinction, because this is really where a lot of motions to amend have fallen down. Patent owners have not provided the showing that the board is requiring them to show. And here, what's intended to be shown is that the burden of persuasion is always with the patent owner. So it is always up to the patent owner to show that the claims that are being proposed are patentable, including patentably distinct and containing patent-eligible subject matter. But the burden of production starts with the patent owner. The assumption, as far as filing your papers, is that the patent owner is going to make a prima facie case showing that these claims are patentable or patentably distinct, and then that burden of production shifts to the petitioner, who can challenge the sufficiency of the patent owner's prima facie case and can rebut the prima facie case with additional prior art and or a declaration testimony of a technical expert. Then the burden of production will shift back to the patent owner, who can respond with a reply to the petitioner's opposition. And so what's been happening is that the board feels like patent owners are not showing that their claims are patently distinct. And what a common theme that you'll see throughout many of these decisions, and it often comes down in the final decision if there's been a motion to amend, but it can also come down in various orders that the panels issue when they're talking about failed motions to amend, is that this is not an examination type proceeding where an examiner is putting up arguments that the patent, at that point, an applicant would be rebutting against to try to get claims allowed. Rather, this is a situation where the patent owner has to play both applicant and examiner and show the board that all prior art is being considered and demonstrate to the board why these proposed claims are patentable in light of all prior art that may be relevant. And so in idle-free systems, in the guidance, which is initially in the order, the board said that the patent owner should identify the feature or features that have been added to each substitute claim and show the patentability of these new features relative to prior art of record and prior art not of record but known to the patent owner. And the patent owner needs to make a representation about specific technical disclosure of the closest art known to the patent owner, and the patent owner can rely on declaration testimony of experts. And the board really expects the patent owner to explain why these claims are patentable, rather than merely saying the closest prior art of record does not render the proposed claims obvious. That's simply not going to be enough. The petitioner can oppose the patent owner's position on patentability, as I said earlier, in the opposition to motion to amend. This is additional guidance that was provided in idle-free systems in the final decision. And here what the board did was they looked at the renewed motion to amend and ultimately decided that the claims would not be granted, the motion to amend would not be granted. And here's some of the reasoning. They say that the patent owner is not assumed to be aware of every item of prior art known to a hypothetical person of ordinary skill in the art. However, the patent owner must set forth and discuss for each added feature the level of ordinary skill in the art, what was previously known about each added feature. For instance, was the patent owner the first to know or use the added feature? If not, what was known about the feature, or how was it previously used? Was the feature used in other contexts or industries, and if so, why was it not obvious to use the feature in the current context? And I'm going to skip to what I have here listed as my last slide, but I'm going to do that and then come back to master image. These are 4 decisions that occurred between the idle-free systems and the master image decision, where the patent office, the PTAB, provided additional guidance. And this international flavors was the first case where the PTAB granted a motion to amend. And something that's noteworthy here is that actually the motion to amend was unopposed. The patent owner did not file a response, and they actually canceled all of their claims. And if you'll note, the patent owner in this case is the United States of America. I don't know if that had anything to do with it or not. But the patent owner here limited their claims. What this case was about is a method for repelling arthropods using a class of chemical compounds. And in the motion to amend, the patent owner limited the claims to 5 very specific compounds. And the patent owner provided declaration testimony and additional prior art where they demonstrated the patentable distinction, including why it would not be obvious, why these new claims weren't obvious in view of the prior art. And a part of that being that a change in chemical compound gives you different chemical properties such that the prior art did not obviate the claims that were in the motion to amend. This next case, Corning Optical Communications, this was actually just an order that enabled the patent owner to file the motion to amend. And the board looked here at written description and talked about the fact that the patent owner must go to the original filed application for written description support, and that the patent owner needs to provide claim construction for any claim terms that they reasonably believe that there may be a dispute over these claim terms. Again, they said that the patent owner is expected to reveal what it knows that's in the prior art, but there does not have to be some sort of scorched earth searching done by the patent owner to reveal everything that one of ordinary skill in the art would know. In Riverbed Technologies, the Silver Peak Systems, this was the final decision where, again, the board granted 2 motions to amend, and this was actually an opposed motion to amend that the board still decided to grant the motion to amend for 2 claims. In this situation, the patent owner added a significant number of limitations to the claim and also provided a substantial amount of information and prior art, explanation, demonstration showing why the claims were patentable. The patent owner actually did not provide an expert declaration in the motion to amend here, but the PTAB said that was fine because they provided so much explanation with the prior art that they put in their motion to amend. And the last case here is REG Synthetic Fuels v. Neste Oil. And this is a case involving production method for biodiesel. And here again, the patent owner had provided a significant amount of explanation, including expert declaration testimony in this motion to amend, explaining why the claims were patentable over the prior art. And the petitioner tried to argue that there was prior art that the patent owner should have included in its motion to amend, but did not. The PTAB ultimately said that the 3 pieces of prior art that the petitioner was bringing up were not relevant to the issue that was raised by the new claims, that these 3 pieces of prior art had been prior art of record because the patent owner had used them in its teaching away argument in trying to argue that their claims were actually patentable and not invalid. And because those 3 pieces of prior art were not relevant to patentability of the proposed new claims, that the patent owner did meet their burden of proof and did show that the claims were patentable. And going back one slide to this master image 3D versus real D, and this order came down in July of this year, and the PTAB again took the opportunity in an order to provide additional guidance or clarification to patent owners on what they mean by prior art of record and prior art known to the patent owner. I'm not going to read through these because I want us to have some time to get to questions, but the point at the bottom is important. And the board said that a patent owner's initial focus in the motion to amend should be on added limitations and features, and that prior art related to the added feature can be material even if it doesn't address all of the other claim limitations. And this is getting to closest secondary references that may have not been material or relevant until these new features were added in the substitute claims. So I went through these really quickly. If you have additional questions, feel free to send me an email or contact me, and I can send you these slides. And here's your 3rd CLE code, and it's September 29th. And now, in our last few minutes, if anyone has any questions, we'd be glad to try to answer those for you.
I got a couple here. What are the biggest differences between a district court case and a case before the PTAB? I guess 4 immediately come to mind. The decision maker. Typically in district court, you're going to have a collection of individuals, a jury, who lack the technical expertise and comfort level with patent law that your PTAB judges have. And so if you have a good invalidity case, a solid technical invalidity case, I'd rather bring it to the PTAB. If my case is weak, then maybe I go to a jury and take my chances that they'll screw it up and find it in my favor. I don't know. But it's the decision maker's a key difference. The amount of discovery. very focused in the PTAB, not so focused at all in district court. Cost, it's cheaper to fight the PTAB than lose in district court, and the chances of success are greater in the PTAB than they are with at least with a jury. I think juries, they're okay finding non-infringement, but I think they get a little uncomfortable taking a patent away from somebody, especially when the inventor shows up and testifies and tells a great invention story, and they like the inventor. They're just very reluctant to take the patent away from the inventor. So those are the big differences. The other question is, do I think filing rates for IPR petitions have plateaued, or will they continue to rise? I think they're going to continue to rise. With one caveat, it's still early in the game as far as the Federal Circuit and how they're handling appeals of these decisions. But unless the Federal Circuit does anything crazy, I expect the PTAB to be the place where you're more likely than not to succeed on your invalidity case, and which means that people who are charged with infringement will choose to fight the invalidity battle in the PTAB instead of district court. So those are my thoughts for what you're working. John, do you have any questions?
Yeah. So one of the questions that I received, I tried to answer it during my presentation, but I'll just reiterate right now. Which proposed rules have the most dramatic effect? And I think there's two. One is the preliminary response, because that gives the patent owner another forum or avenue to challenge the petition before the institution decision, and then also the page limit, I think, may be the most dramatic change of all of these, because page limits are so crucial in the PTAB, and they really affect the way that we decide what gets in, what do we have to cut, and also the way that these page limits, instead of page limits now, they would be word limits, like I talked about. I think that changes the way practitioners are going to construct their petitions. And then the most surprising rule change was the other question. And I think that one is the Rule 11 type certification was surprising in that all of the other proposed rule changes, the PTAB had telegraphed those by back in the spring. The PTAB had issued a request for comments on rule changes that the PTAB was considering. And a Rule 11 type certification is the only thing that's in the current proposed rules that was not telegraphed back in the spring. So that was a bit of a surprise, but I also get why the PTAB is proposing it now to just get in line with the Federal Circuit or the federal rules and make sure that people are on their best behavior. And Rule 11, like I said, it's consistent with the rules that are already in place for the most part, so it's a logical proposed rule. And Alan, did you have any questions?
I did. So the first question is, do you predict an increase in motions to amend filed by patent owners? I think that the patent owners who are going to file them perhaps have probably they're already doing so. And maybe there may be a slight increase, but I don't know that will increase. I did have another question. Do you think the PTO will start granting motions to amend at a greater rate? And I think this is a great question, because I think that really what's happening here is that patent owners are becoming a little bit more savvy and more educated to what is needed to get their motion to amend granted. So I think perhaps and probably more motions to amend will be granted, maybe not because the board is different, but because patent owners are acting differently and providing the board with the information that they've been requesting and that they're saying they want. With one caveat to that, I discussed very quickly the REG synthetic fuels VNSC oil case. And in that case, as I mentioned, the petitioner argued that there were 3 pieces of prior art that should have been included in the motion to amend and that were not. And the board decided that they didn't think that those 3 pieces of prior art were necessary because they were not relevant to the new claims. And in that particular situation, I think that the board could have gone either way. They could have said, you know what, you're right, the patent owner should have brought those up, and then showed why those 3 pieces of prior art were not necessary because there's no motivation to combine with the other prior art references, or either one of ordinary skill in the art would not have an expectation of success. But the board did not decide to do that. So based on this REG synthetic fuels case, perhaps the board is changing a little bit of the way that they're looking at motions to amend, but in any event, I think the answer to this question ultimately would be probably so, with the reasoning being potentially various reasons.
Okay, well, it looks like that's all the time we have, and I think, Joanna, were you going to recap the CLE codes?
Yes, so thank you for attending today's webinar. Once again, the CLE codes are CLE code number 1, Brinks; CLE code number 2, Post-Grant Patent; CLE code number 3, September 29th. Once again, thank you for attending today's webinar.